How to object to hearsay in court. When you step into a courtroom, understanding how to challenge hearsay can make a significant difference in your case. Hearsay refers to an out-of-court statement that is presented to prove the truth of what it asserts. So, how do you effectively object to it? First, you need to be alert when opposing counsel introduces a statement that seems to be hearsay. As soon as you recognize it, stand up if court etiquette permits. Clearly state, "Objection, hearsay." This immediate action signals to the judge that you are contesting the validity of the statement. Next, provide a brief explanation of why the statement qualifies as hearsay. For instance, you might say it is a statement made outside of court that is being used to prove its truth. This helps the judge grasp the basis of your objection quickly. Timing is essential. Make your objection as soon as the hearsay evidence is introduced, ideally before the witness answers or before the evidence is fully presented. This ensures that the issue is preserved for any potential appeals if the judge allows the hearsay evidence despite your objection. Once you have made your objection, the judge will decide whether to sustain or overrule it. If the judge sustains your objection, the hearsay evidence is excluded from the official record and cannot be used to influence the case. If the judge overrules your objection, the evidence will be admitted. It is also important to know that while hearsay is generally inadmissible, there are numerous exceptions. For example, statements made by a party to the case can be used against them. Prior inconsistent statements can challenge a witness's credibility. Excited utterances made under stress or business records created in the regular course of business are also exceptions. If the evidence falls under one of these exceptions, be ready to argue why the statement should still be admitted. Conversely, if you believe the statement does not meet an exception, emphasize this point in your objection. To summarize the practical steps for objecting to hearsay, first, stand up if appropriate to show respect. Second, say "Objection, hearsay" clearly. Third, provide a brief explanation of why the statement is hearsay. Fourth, be prepared to argue whether an exception applies. Finally, wait for the judge's ruling on your objection. Mastering these steps is vital in courtroom proceedings. It allows you to control the evidence considered by the judge and jury, protecting your case from unreliable out-of-court statements.